Welcome and thank you for attending. Questions can be asked using the questions pane in the webinar control panel. A copy of the handout can be found in the handout section. Today's presentation will be recorded. If you have any objection, you may disconnect at this time. The recording will be available on demand following the webinar. I will now turn the presentation over to your presenter. You may begin.
Good afternoon, SHRM, Long Island. This is Henry Shapiro. It is a rather beautiful Friday after the lovely weather we've had this week of heat wave, monsoons, humidity, I think some more heat wave, but looks pretty nice out today. So everybody that is committing to spending 20 minutes with me on the last Friday in July in the middle of the summer, it is greatly appreciated that you will give me whatever attention that you do have left on a Friday when I'm sure everybody wants to get out of the office. So I won't waste too much time other than everybody exploring my witty title of what New York is really doing over the summer. I have a lot to cover. Some of this, Tim Dominic, my colleague, was nice enough to pinch hit for me last month. But some of this is a recap of what he went over, but now it's actually been signed into law by Governor Cuomo. So I figure we should just cover it because it will apply, and it's something that I've said probably on any webinar where anyone's listened, and I've said, why do we care about New York City? Because New York City typically finds its way out east, and whether it's Long Island or Nassau or Suffolk specifically, it gets there. So the first thing we'll talk about is the state salary history ban. For any of you that are already operating in New York City, you know this, you know about this. This is about inquiring into applicants' salary history when interviewing them for a new position or for a position. For those of you in Suffolk County, you have been familiar with this for about 27 days now because it went into effect June 30th of this year. We were talking about it, though, in late 18, early 19. So why are we bringing it up now? New York State, via Governor Cuomo, signed it into law, the salary history ban, statewide. It won't preempt any of the laws on the books, but it will cover any place that doesn't have a law. So Suffolk County, Westchester, New York City are going to already be covered. What is now going to be added is the rest of upstate New York, and primarily for those of you on this call, Nassau County, because you did not have this prior to. So you have a while until it takes effect. It's a best practice to not even be inquiring into salary history because, even before the law, because it somewhat sets the groundwork for the appearance that you might be making a decision for, I won't say an unlawful reason, but for potentially not a good reason, not a reason based on skills, qualifications, or abilities, which is what we always want to do. We always want to evaluate employees and applicants based on their skills, qualifications, and abilities. So the last little bullet point is the plug for myself, because I know I've said on probably about 10 of these webinars, pay attention to what happens in New York City. So a quick primer, the new salary history law will ban any inquiries into an employee's salary history, prevents employers from either orally or in writing requesting or relying on the wage or salary history of an applicant in determining whether to offer employment or the amount of salary to be offered. The employer cannot refuse to consider or retaliate. You're all used to the non-retaliation provisions. You cannot refuse to consider or retaliate against an applicant who refuses to divulge his or her salary history. However, keep in mind this fourth bullet point. An applicant may voluntarily provide information if they are not prompted or coerced into doing so. So don't try to be sneaky and get them to divulge it. But if they tell you, because we don't expect our applicants and our employees to be experts on the law, in the event that they willingly provide the information without any prompting from you, that's fine. I would just caution you against acting differently. The knowing the information is fine, but if a position calls for you to be hiring it at $50,000 and the former employee or the applicant tells you that in their former employment or even in their current employment they're earning $40,000, you shouldn't drive it down. You should hire based on what the position pays. That's kind of the nature of this entire law. It wants you to evaluate what you think a position is worth, regardless of maybe somebody got screwed in the past by a prior employer, or maybe they really should have been making the 50, or maybe even more than that. They don't want you, new employer, making an adverse determination to lower someone's pay kind of arbitrarily simply because you have a former employer who didn't do the right thing. So some comparisons between New York State and New York City, a good place to focus for those of you with operations in the city so you can see what the difference will be if you're out in Nassau County. Similar, law applies to job applicants not currently employed by the employer, as well as the employer's current employee seeking a new position within the company. The difference, the city law prevents employers from conducting a search of publicly available records. This really matters for public employers, if any of you are on the line. The government salaries for all public employers, and I'm sure you can all think of MTA, any public employer, you can find that out online. It's publicly available. So we want to be careful when looking at that information. So technically there's an avenue under the state law to do it. It's not something you should still probably focus on. It's not a good practice to get in the mind of. So I got to clarify this. The last difference. The New York City law applies only to applicants, not to current employees. And then we obviously have that first one where we talk about that the law applies to job applicants not currently employed by the employer. Just to clarify, both laws cover applicants. That's without question. The city law, it is not clear that it applies, and this is what I kind of want to speak about. It's not clear that it applies to current employees. However, based on what I've already told you, don't get in the habit of, making arbitrary decisions for even your current employees when you're looking to transfer them to a different position. Maybe you're putting them in a different location. Maybe you're giving them a promotion, whatever the case may be. When you are doing that, the place you are moving the employee to, the position you are moving the employee to, that should really, you should have a predetermined thought on what that position is worth as far as in your business. That's how you should determine payment. It shouldn't ever come up to any protected category. You shouldn't ever have anything coming up where you are going to disadvantage somebody who might be underpaid. You want to basically make sure we pay people properly. So although it is somewhat unclear that the New York City law, in writing, it does not apply to the current employees, but you want to be careful if you're in New York City, especially because, I catch myself more and more nowadays. Every question that I get asked by a New York City employer, you really got to think twice about it because almost everything is protected. So you really got to, things that you maybe used to do 5, 10, 15 years ago without hesitation. Now, I will tell you, myself, my colleagues, we all kind of have to think twice and talk it out amongst ourselves to make sure this isn't triggering some kind of protection in New York City. What should you do now? Nothing in the law restricts inquiring the salary expectation. So worded correctly, you can find out what somebody is looking for as far as what they are expecting with their salary. You cannot, again, inquire into their past salary. You can't try to skirt the law by calling former employers and asking them to help. There's aiding and abetting liability. You don't want to coax somebody into helping you break the law. What you are looking to do is if you want to get their expectations, so maybe that this position, no matter what that you were hiring for, is for $50,000. If they are expecting $100,000 for this position, then you know that it's not going to work. So maybe it's not worth wasting anybody's time. If it's just this is a $50,000 position, so we hear you saying you're wishing for $100,000. That's not what this position pays. That's an okay conversation. In anticipation of the effective date, employers, especially those of you in Nassau, because again, Suffolk has a law, New York City has a law, Westchester has a law. Everybody, but especially Nassau, should review and modify your employment applications, interview protocols, and verification policies to exclude inquiries that relate to a job applicant's salary history. Training, and this is the last one I strongly recommend because I have litigated cases where an interviewer doesn't know what they are allowed and not allowed to ask, and you sometimes get these wise applicants who come to you and bait you into claims. Sometimes they're sent by plaintiff's attorneys. Sometimes they are just opportunistic on their own. But make sure everybody is trained on what they can and cannot discuss, because somebody might say, oh, yeah, what you used to make there? And maybe they don't mean anything, no ill will, and they're just trying to be friendly and maintain a conversation, but that right there would be a violation. Equal pay for equal work, changing gears. This was also signed by Governor Cuomo on July 10th. It becomes effective a little bit sooner, October 8th. Everybody will know the October 8th date is also the day you have to have all of your employees trained for the New York State anti-harassment law. If you have not done employee and management training for everybody on your staff by that date, you will technically have a violation of the law. So please get everybody trained. If you use us, reach out to whoever you work with. If you use alternative counsel, reach out to them. Get those people trained. We've had about a year to do this, so we want to get that done. The new law prohibits wage differentials based on protected class status. What really this is two major things. It's expanded beyond just sex and gender. It now covers all protected categories, so there's got to be equal pay for equal work. It may be a law, but I would hope that everybody that's preaching and practicing good employment practices within in-house are following these practices already, that you are giving equal pay for equal work, that someone's protected category, their race, their age, their gender, their disability, whatever it may be, does not impact how you pay them. You should be paying based on the work done and the position that the person is in. The other change here is we go to a substantially similar work standard rather than always having to be equal work. It could be one or the other. Substantially similar is obviously a little bit less than equal. Equal is exactly what it means. Equal is the same. Equal is equal. Substantially similar, a little bit more employee friendly, a little bit more room for gray area. Because now it's what is substantially similar. There's going to have to be case law that's going to come out, and most likely we'll never have specifics to your positions, but we'll have to determine, it was equal when, you have a vice president of sales and a vice president of sales. Now, what if we have a vice president of sales and a vice president of finance? Are those equal? Are those substantially similar? We don't know. You got to look at the duties. So, as I said, it lowers the burden of proof. Pay differentials are permitted in certain circumstances when they are based on a seniority system, a merit system, a methodology measuring earnings by quantity or quality. So basically a production increase or a production bonus. If you produce a certain number of widgets, you get this much more money, or a bona fide reason other than the individual's membership in a protected class. So I've gotten some questions this week from employers about, do we just have to pay everybody the same? No, that's not the intent of the law. The intent of the law is to pay everybody in similar positions the same and not make decisions based on protected categories. If somebody has more education or more experience or is just a better performer and it is well documented, you are absolutely free to continue pay differentials because those are all legitimate business reasons. I would always stress that those things are documented, because otherwise it's going to be your word against somebody else's. And how do you prove that somebody was really a better performer? It's a fight. So what should you do? Review compensation and benefit programs, looking for pay inequality amongst protected classes. If you're a large employer, that's something that certain law firms can do. It's something that we do here at Jackson Lewis. If you're a smaller employer, you probably can just do an eyeball test and take a look to see, hey, do we have pay differences? And why? Maybe you'll find some, but maybe one is a 10-year employee and one's a 1-year employee. That's a good reason to have a pay difference. Review your internal practices for determining pay for new hires and increases for current employees. That's obvious. You want to just make sure you're doing everything on the up and up. The third thing is something you've probably heard any labor and employment attorney beat to a pulp. Best practices are always the bottom three things. Have a legitimate business reason for any decision that you make, document it, and then be consistent in the application of your policies. Last two things that we're going to cover very quickly. Liens on employers for alleged wage claims. So last week, a bill aimed at increasing protections for employer wage theft. So not paying the minimum wage, you're not paying overtime, By allowing an employer, the bill allows an employer's current or former employee or the DOL to place a lien on the employer's interests in real or personal property for the value of a wage claim. So this is a scary one. It's not law yet. If it does get signed into law, it'll take effect 30 days after signing. But what are some wage theft? You already know. A lot of you, I'm sure, are familiar with some of these: minimum wage violations, failing to pay overtime, tipping violations. The bill permits workers to put a lien on an employer's property in connection with an alleged wage claim. So that's what's a little scary about this. An allegation. Doesn't have to be proven, doesn't have to be a judgment, it's an allegation. So we went over what a wage claim is. Cannot place it on bank account, and employers' bank accounts are good, so that's great, but still have the real or personal property. The lien may be filed at any time, but not later than 3 years, so they have quite some time to do this. They have a 3-year statute of limitations following the end of employment. The issue I want you to focus on is this third bullet point. Of the handful of other states that already allow similar liens on employers, only one, Wisconsin, allows such liens based solely on allegations rather than a finding of liability. So again, that's the scary part here. There have been several opponents to this bill. It's unclear right now if Governor Cuomo will sign it. I'd say that the money is on that he will, but the scary part is that it's just, if an employee makes an allegation, they are going to have a lot of leverage now, because then they can use that allegation to go place a lien on the employer's property. So we are, what opponents have been afraid of, what some of the attorneys that I work with are afraid of, unintended consequences. So a potential freeze to credit needed by small businesses when a lien is filed, because banks may not extend credit if they see these liens on the employer's property. And again, unfair leverage for the employees. This is giving employees quite a carrot. Who knows how quickly they'll realize it, but who will realize it? The DOL and plaintiffs' attorneys. Last thing we're going to cover is the recent decision in the Southern District of New York, which is the SDNY, the FAA. This is not the Federal Aviation Administration. This is the Federal Arbitration Act. Preempts the New York bar on agreements to arbitrate sexual harassment claims. So anybody who was listening over the last, year plus at this point, it's probably getting closer to 2 years at this point, with the sexual harassment legislation that came down in New York State. One of the items that went into effect in 2018 was the ability to have an arbitration agreement that compels arbitration for sexual harassment claims. New York, as part of the law, said you can't do that, cannot compel arbitration. However, now, just as of about a month ago, exactly a month ago to the day, we have a Southern District judge, a federal court, saying an agreement to arbitrate sexual harassment claims is enforceable pursuant to the Federal Arbitration Act, which goes against the New York State law, this is a good, just to be clear, this is a good thing for employers. I know I've given you a lot of bad. This is a good. So the New York law does not preempt the Federal Arbitration Act. The Federal Arbitration Act and the case history on it is pretty clear. 2018 law, just so we said, just to cover it, says prohibits contracts that require the parties to submit to mandatory arbitration to resolve any allegation or claim of an unlawful discriminatory practice of sexual harassment. A fancy way of saying you cannot, under New York law, you cannot be forced to arbitrate a sexual harassment claim. However, with this Southern District ruling that is now, since I believe just today, it was appealed up to the Second Circuit Court of Appeals. We will follow that with eager eyes to see how that turns out. We expect that it's going to stay this way because, again, the case law on the Federal Arbitration Act is very clear. There is a strong favor of arbitration in the history of the law, including up to the Supreme Court. But here in the Southern District of New York, the court held that the 2018 New York law violates the federal requirement that arbitration agreements be treated equally as any other contract. Latif, which is the name of the case in the Southern District, confirms that employers that are covered by the FAA, which is going to be basically everybody except employers in the transportation industry, confirms that employers that are covered by the FAA can rely on arbitration to resolve disputes over sexual harassment, notwithstanding the efforts of a state legislature, New York, to limit the claims that may be sent to arbitration. So this, I purposely put this at the end. It's something that we will watch, with bated breath. It is also something that is a good thing for employers, so it's a good ending. With that, 12:20 on the dot. I thank everybody for joining. If you have any vacations planned, have a wonderful time. If you are going to be at work like myself, have the best time you possibly can. But enjoy the weather, enjoy your weekend, and have a great summer. I'll talk to you in August. Take care.